Greetings. I wanted to spend a few minutes talking about law, social control, and science. And again, we could have an entire course just on this topic. Uh, Professor Fagman in 2000 published a book called Legal Alchemy, The Use and Misuse of Science in the Law. Some of the features that were pointed out, for example, is that science and the law have very different approaches. So the legal approach and the scientific approach differ. And that can be a problem when scientists study law and when attorneys use research. Uh, and so that's something we want to consider and take a look at. And in science, advances are seen kind of out there in the future, and there's a big focus on being innovative and creative and challenging the status quo. The opposite really is occurring in law, where we have a focus on the tradition of the past and legal codes, and kind of a focus, as Fagman points out, what should be, what ought to be, and also supporting the status quo. We also see that there's the free will versus determinism debate that occurs in the legal system. Really, how much of behavior is determined by outside factors, the environment, for example, neurology, brain-based functioning, versus free will, the ability to make decisions what to do. And Fagman points out that science and scientists cannot prescribe policy. And some might disagree with that, like myself. I believe that science and scientists can prescribe policy, but I think that there's certainly some problems with that, and there's a lot of debate in the social sciences if scientists should be involved in policy making. So I'm from one school of thought, and I want you to know there's another very strong school of thought that is in the opposite direction. And I'm not going to say one is correct and one is incorrect, but there's just different views there. And he also points out that legal professionals must understand science to make science policy, and legal professionals are responsible for setting policy science, which can lead to some interesting debates and arguments. One of the things I would mention, for example, would be that politicians propose, to do something to solve some problem. They make some policy to solve some problem, and as a researcher, that a bunch of research has shown that actually what they're recommending has been demonstrated in the research to either not work or to have a backfire effect and actually make things worse. Now how do you navigate that situation? There's a lot of policies out there and suggestions I hear that politicians and policymakers make, and I always ask myself, well, what does the research show about that? And it's a difficult situation sometimes because the research may show something that's very unpopular in the public or in the politicians' domain, and so this can become problematic as well. I'll give you one example: corporal punishment, and what the research shows about corporal punishment, what the public believes, what politicians believe, how we talk about it, and certainly one big debate that's occurring right now is whether or not, I guess, to legalize medical marijuana. And there's all kinds of debates on both sides. I'm not going to get into those debates, but certainly we could bring in research there. And also in the courtroom and in the public, we might ask, what makes someone an expert to talk about the science that they work with? How do we make sense of situations where they're experts on both sides in a courtroom scenario? And certainly we see that before the defense brings in a couple experts, the prosecution brings in a couple experts, and they disagree very strongly. They may say, And we see that, one says one thing and the other says another. And of course, the jury or the judge and the public are trying to figure out how to make sense of this. What does the public think? What do they do? What do juries do? How do they make sense of that? That it can be from the physical sciences, or it could be from the social sciences. And so the expert witness in cases certainly relies on research and presenting the research in the courtroom. When I worked in clinical practice, I was able to testify in some cases, not as an expert, but as someone who had an opinion and had some background, and I would say, well, the research shows, and then get in some debates sometimes with the opposing attorneys. So those were interesting cases, and I would often carry a briefcase with 5 or 6 recent articles and a book or two to present in the courtroom. But I found out a lot of times it didn't really go over that well. The last thing you want in the courtroom is someone opening their briefcase and taking out a couple books and reading from journal articles. They want summaries, and sometimes that can be problematic as well. So we see this, one of the interesting areas which I think we all have an interest in looking at in criminal justice is recidivism. How likely is a person, to reoffend for a particular type of criminal behavior? And again, you have a lot of debates about that. You have a lot of research on that. Also, we have to contend with the so-called CSI effect, and really, has that occurred, or do we have improved technology that has increased so much in sophistication that it's kind of expected that society says? Some of you who work in law enforcement may have experienced what we'd call the CSI effect, when vandalism occurs, let's say, and the person, the victim is saying, okay, I want you to go ahead and take, prints. I want you to, take, do the shoe print molds and all that. And don't you have some laser technology? Is there any DNA you can type from the doorknob? Then they pulled out my doorbell. Well, certainly. And, you're trying to think, well, how do I tell this person, it's going to cost you $20 to replace your doorbell, but it would cost a lot more to do all those procedures with time and effort and cost of DNA typing and all that. So I mean, we kind of see those situations. Some cases get more science than others, and I'm not sure why, and that's certainly something that can be looked at in more detailed and researched. One of the strangest cases I've ever seen was Dr. Lipstadt, who was sued in a libel case and had to prove in a court of law in England that there were gas chambers in the concentration camps during the Holocaust, which she did. And there is a movie that is just coming out about this particular case, which should be a fascinating movie from a criminal justice and a legal perspective, but also if one has an interest in Holocaust studies as well. A lot of times we may find that we can work behind the scenes in preparation for legal cases. I can tell you I didn't like going to court. Because often it involved a lot of waiting. It was always an adversarial situation. And back when I was going to court, we were not obviously as sophisticated with computers and everything else that tablets and everything else that we see used today. I knew that things weren't going well when I was going to testify against an alleged offender, and went out in the waiting room and sat down, and the alleged offender sat down right next to me, and we kind of waited there for a half hour or so before going into the courtroom. It's kind of an awkward situation. We didn't talk to each other, but I'm pretty sure he knew who I was and I knew who he was. And it's just when I told the state attorney about that, state attorney said, "Oh, we could put you in a small closet type room and have you wait there." But I said, "No, that's okay. I'll stay out here." So I mean, you know how it goes. If you've been in working in the courtroom situation before. But then you get all these situations reviewing cases, in case preparation, mental health cases, homicide cases, child custody, insanity pleas, cases where groups are involved, post-trauma effects, and then, of course, rare and unusual behaviors. A lot of times I would find when I worked in one particular facility that I would get calls regarding very unusual behavior and asked, what to do here. A lot of times it was kind of a situation trying to figure out what do we do with this person, which is most like what kind of treatment would be appropriate for their unusual behavior. And I'd try to make some recommendations, but the goal often was to keep it out of the courtroom and to work out, plea bargain and treatment and, diversion or whatever, because of the nature of the bizarreness of the case. And then risk. And Hannah Moffat talks about risk and that we've moved from static to dynamic factors. And this has led to new risk need management models. And along with this, we have new politics of punishment and also competition for scarce resources, discrediting particular group claims, and also the redistribution of responsibilities. And so basically, if we look at risk, again, Hannah Moffat in the 2005 article, Criminogenic Needs and the Transformative Risk Subject in Punishment and Society, volume 7, pages 29 to 51, talks about the different generations of risk assessment. For example, the first generation of risk assessments was more clinical prediction by a clinician, which is relatively subject. They get interviewed and they kind of do some observations. Second generation risk assessments focused on statistical prediction using static variables, and those are ones that are stable, ones that really do not change, focusing maybe on the person's history, or how many times have they been arrested, how many times have they been found guilty of particular crimes, or their gender, things like that, where they were born, those are some static variables. And we see that a lot in risk assessments, and a lot of times they don't tell us really what's currently going on. The third generation risk assessments measure static and dynamic risk factors, dynamic ones that can change. And the fourth generation risk assessments, which was kind of discussed in the future, and I think we're really focusing more on that now, is the identification and the measurement of key responsivity characteristics for treatment. In other words, what specific treatment program is going to benefit and meet the needs of a particular offender. So the attempt here really is to basically match the treatment to the risk level, and also target the criminogenic needs, and also look at what treatment would be the best one to use, or the one to get most likely get a positive outcome with a specific offender, while also allowing professional judgment and discretion as well. And so we kind of see that situation occurring as well. So those are some of the areas that I just mentioned that come into play when we kind of look at law, social control, and science, and how it all fits together. And of course, looking at our different theories and types of social control, that all plays in there as well. And this wraps up this video.